the first to know. Nsem-Pii TV.
Me that so me wo the Supreme Court of the land. Earlier on, me the video bremo ema said the Attorney General have filed the appeal document appealing an earlier ruling by the Court of Appeal discharging and acquitting Dr. Casey Latoforsen and Richard Japa in the 2.37 million euro ambulance case. Michiremo ruling 2-1 ruling about appeals court. Any enyina soa the Attorney General ejina so edi appeal ewo the Supreme Court. Enya no kwa, there's another thing in it person me no dey hun komo. The Attorney General assigned listed various errors. Yeah, the appeals court in its 2-1 ruling of a submission of no case for the first accused, Dr. Casey Latoforsen, and the third accused, Richard Japa. Chika semu, the person me chire say, Attorney General, to me, I chire and from swaho doa o de bagana mremu a osusu say appeals court nhihye ya omode betu dwa say yenyai Dr. Casey Latoforsen and Richard Japa na ebom. Na ohwe document no a ye ni series na me adom china media another aspect of the appeal ebebremo wa wo transe na in fact utie na odwene ho a ebema we fair idea of what to expect when Supreme Court calls this appeal case. Now me hwe errors no particulars of errors no me hu I V just say doors yi enfun so ahodo a Attorney General ehu no e wo the ruling of the appeals court enunti Supreme Court nyina so na ommo saa acquittal and discharge ruling no emfantungu na onsantwe Latoforsen and Richard Japa emegina dakanimu na ommo entoa the opening of the defense so. Now error number 1 said the be ameye no making kind na mabomodin say me chirimu ama watiasi or say the majority on the Court of Appeal made this finding based on an assessment of the evidence at a time that the first appellant or respondent had not opened his defense to enable his position to be known. Attorney General Chirimwa. Sa majority judge for me no findings are omugina so edichire said there is enough evidence say ye de bebo Dr. Casey Latoforsen for causing financial loss to the state according to the Attorney General. Wakenkan omo ruling omo findings no any assessment no ya omo ye na ni nyina gina bra na Dr. Casey Latoforsen open defense ma ye hunu ni gina bia nkasa e wo case ni e yesa brem na these two judges e gina so e de ye omo findings and omo assessment of the evidence. 2 particulars of offense or say the majority on the Court of Appeal failed to appreciate the fundamental point that acting in an official capacity is no defense to the offense of willfully causing financial loss to the state. Ahanchiremoni say the thing. Attorney General say uwajumam na panyi ya wo hye nase eni ho na wakwa gina mu ama no aye bibi ya de kro no a wo ye no e de ekabuburu abresa adwumakuo no enkyere se yentumi encharge for causing financial loss to the state. Let me give you this clearer example. Me ye teacher ni me chere commerce e wo GHS. Me form master e chere commerce wo GHS 3. Me chere commerce wo GHS 2. Me form master bibi nti wantumi ama na wo de jam se me nkonko chere commerce wo GHS 3. na me chi akoda bi ye bone na me chi no bona ba ma ne to paye a eno nkyere say because se me gina ma me form master ninti ma akoda na ba ma ne to ampai ma ba akoda na ba ma ne to apai. So me acting on the official duty of my form master doesn't exonerate me from the fact that ma ba akoda na ba ma ne to apai. And ma ba akoda na ba ma ne to apai no, it is an offense ya me na me ye. Though I am acting in the official capacity of my former master there, but akwadane to na apaye no as a result of abani de eyeme na boy. So I can be charged for that offense, though I am acting on the official capacity of my former master. Sanchiri mono and anatori general say. Or the emfane say ato force now acting on official capacity of the finance minister here say tepe. But in krata no a wogina na na sin sign e de ka na abere o man e no de yentumi charge no for causing financial loss to the state ara. Error number 3 or say the majority decision failed to appreciate that in criminal law acting under superior orders is no defense. So o de ba emra ya eye criminal emremu a se me gina ma ye bibia ma obi no ye mfa ntwitwa nye ye hu because o gina mu ama nipa na de na wo ye no e de kaba e de susuanso obone aba eno ye mfa nye ye hu no se me gina ma obi in criminal law. This is according to the Attorney General. Now number 5 or 6, the majority decision ignored the clear evidence led by the prosecution that officers of the Ministry of Finance relied on the directives of the first accused in the process to establish the letters of credit and not the substantive minister. And Attorney General say, and krata di adanse say, adwumayefo mpanimfo ya ewo Ministry of Finance eye doctor ato forcing edumu asem so ena omu gina so ema sa letters of credit ko Dubai no ekoye siketua enye se tepe no mu ase. Though se tepe is the substantive minister of finance then, but enye onu na no mu asem so ene gina ma siketua ko so eye ato forcing edumu asem so ena officers of the finance ministry gina so ema sa 2.37 million euro no ekoye payment. And also according to the Attorney General, yansha no so sa ebien. Error number 5 or say the position held by the majority that the prosecution ought to have proven that the Minister for Finance, Sir Tepe, did not authorize the establishment of the letter of credit was unjust and unreasonable. Sorry. And Attorney General say, sa gina yesie ya ajagifo mienu no gina so say na wo senka Attorney General mum ene kire say yewra say Tepe enye ono ene ma atofo sentumi no sa enyina so no mu gina so in their ruling no. 1 na pepere yo enim, it was unjust. 2 na entasumo, it was unreasonable. Error number 6 or say the first accused appellant or respondent at close of prosecution's case had not given evidence of any authorization he had for signing those letters of credit. And now, Attorney General, anya bia ebra na yewura ato forcing edi ni nsem nyina ebewiye when to me ama to me krata bia na edi adanse se yewura se Tepe ene man to me se onsen sign san krata no a yedi kotua sika 2.37 million euro edi ka twiri die bro man to me krata bia ni hono mo a na eya adanse dia kire se yewura se Tepe ene man sa to me yewura to forcing o close ni case when to me an chire to me krata bia sa. Error number 7 or say the majority on the Court of Appeal ignored the clear evidence led by the prosecution that the first accused act in authorizing the establishment of letters of credit directly resulted in the shipment of the vehicles into the country. And I hear Attorney General say, I judge if we no more majority side. Yawade bi omoto gui. Yawade bi a omo ikino. Eyade ben. Say, eyeye wura atoforcing ni tumi krata eko Dubai na eko dani siketua no. Enu ena ehye Dubai fo no kutu pase. Omo nso emfa saa cars no a na enya fit for purpose no. Ensi poso emfa mre ye wo man yi mu se ya ambulance no a ye hwehwe no. Se saa tumi krata no anko ye siketua enka omo anya tumi se omo ship those defective vehicles e dia bre. But then nam se saa tumi krata no ko ye siketua ne ensa ko hye omo no mu nti ene omo de saa defective vehicles no bre ense e ambulances ne enfa nyadwum. Ere tosom nhotwe. Ose the holding by the majority of the Court of Appeal that the claim by the prosecution of a lack of parliamentary approval for the transaction was an afterthought is fraught with errors, unfair to the prosecution, and has occasioned a substantial miscarriage of justice. Attorney General say, Judge for me to meet transika say, deal near course nina, and crate dia dance say, na Ghana mrase beja, enyim to me crata entire chiri. Na sa semno, a yadia, ye jini ansana, ye transacted dinwa, na no kribieni, na yadia, as a result of miscarriage of justice, because a parliamentary approval and both ministries so e dia yedwuma enti nyase ye kura contract ni mu awie na pa hyehye ya dwene ho say does it conform to parliamentary approval or not there be nyasa na contract net and Attorney General chire mu bi say the lack of parliamentary and other necessary approvals form part of lack of due course and authorization aptly captured in the particulars of offense. And Attorney General said, particulars of offense. Ya was submitted ya audition mu say lack of due course and authorization. Na emu ba ko ne say kwanya contract ne fa so ya Ghana nsaka ahyenya enyina brane si ye de be ambulance no. Na emu ba ko ne say saa contract no a ekofa saa nsem yi nyina bae na Ghana mrase bedwa ensan hyase saa nso na ministries ana ye involved no ebi anyi antum enunti and a particulars of offense ni ewo bibi wo my friend lack of due course because according to the original memorandum of understanding the contract was between Stanbic Ghana Limited and the Ministry of Health, not Big C General Trading Limited. So, Stanbic was bypassed at a point and the contract negotiated directly between the government of Ghana and Big C General Trading Limited. Hence, that contract was not subject to parliamentary approval. The Attorney General said, Nsem-Pii and our day, sa lack of due course and authorization this year. Attorney General said, the prosecution's evidence led at the trial showed a lack of parliamentary approval for the transaction, which was international business or economic transaction. Was a prosecution no adansi dia hodo ebeto dwa say deal na course one international business between two countries, Ghana and Dubai. Na Ghana mrase bedwa enyintu. prosecution was not required at law to explicitly state lack of parliamentary approval on a charge sheet filed in a summary trial when say is contained in the evidence lead. And Attorney General say, na enhye bia na prosecution ya ye wono no so say chinchina krata wode bo atoforcing ene japa kwadun ontwena fa nhyem say di no mo ye no na Ghana mrahye bedwan ensan hyase esane say adansie krata na adansie ahodo mu no di ka twere dia hye say adekodie nti amese enipa so mesi abon yi ka ne say anama otu ye no adansie kita mi kire say na Ghana mrahye bedwan ensan hyase. So it was provided in the evidence. Hence, there was no pressure on the Attorney General to state that in the charge sheet. Said the two judges in the say, so lack of parliamentary approval and any charge sheet so in the form to force and the Attorney General. The majority on the Court of Appeal was wrong in holding that the trial judge amended the charge sheet for the prosecution. And Attorney General actually mo san sem no a judge fo mienu eno kan say trial judge Justice Efiase Wasare Butwi na wa amend the charge sheet for the prosecution eno kure biasa eni ebium or say the majority on the Court of Appeal gravely misconstrued a report on a visit by the National Ambulance Service to Dubai as an addendum to the contract between the government of Ghana and Big C General Trading Limited. And some no bobo bano ane niya yenyan. Ghana Ambulance Service do mani chire mu Dubai. Jaji mienu chire mu a, chire mu do mani chire mu Dubai ne chire se, omuko carry out pre-inspection. Ansana ye shipo those vehicles. And Attorney General chire mu a, sa visit no muko no Dubai na enye addendum ya ne wo contract nim say yenkoye pre-inspection works enye no ho visit eno muko Dubai because that time Ghana Ambulance Service eco Dubai na already first batch of the ambulance e can crab be do that. It was not an addendum to the contract between the government of Ghana and Big C. Next, I say the Court of Appeal erred when it concluded there was no nexus between the respondents and the offense. The judgment is unreasonable having regards to the evidence on the record. Next, the majority failed to consider the evidence on record that the Ministry of Health specifically ordered Big C General Trading Limited to stop producing the ambulances before the vehicles were shipped. And these two judges, they failed to consider say adansie wo honom a echere say ministry krono a wono kra ambulance no etwere krata de koma Big C fo ne say de omuti Dubai ho ye 207 no omuti Dubai ho hyehye no omompe enti omunyai omompe sa ambulance no enti omunyai Big C fo antie still eshipo sa ambulances ne de buy. It is on record say Ministry of Health no a omo na request for the ambulance omo hu de na Big C fo ne ye they ordered them to stop. Why did they order them to stop? If it met the requisite specifications of the ambulance and Ghana here, DNT that the Ministry of Health order Big C said they should stop the production of those ambulances. This is the question. Yeah, the Land Attorney General, Ebisa. Ebi say the majority failed to consider the fact that the Ministry of Health never requested the Ministry of Finance to authorize Bank of Ghana to establish the letters of credit which were used to pay for the vehicles. This is also evidence on record. And Attorney General Chirima, mi wa dansi die krata en to mi krata ho do ekita mi a echere se Ghana pomuden asoyem fatu mebia masika sema asoyem ne se Bank of Ghana Money konko tueska. Mayanfankwaji those vehicles. There is no such document stating the fact that and are authorizing the Ministry of Finance from the Ministry of Health to authorize Bank of Ghana to establish any letters of credit. Ebi anyho. Enti say letters of credit no a Ministry of Finance a share Bank of Ghana man establish ya yedi ko tua sa vehicles ni kam according to the Attorney General. Krata bien we di adanse ye say a Ministry of Health for na no moto ambulance ama Ghana no ene ma sa atumi. Inti ene why ne ma atumi no say yenkonko tueska na mra the ministry responsible for the purchase of those ambulances are not the ones that give the final authority. And then some of the questions Attorney General bisa will free say a funso e will rule in appeals court to the buy. Ebi on say the majority ignored the fact that the first accused, without any request from the Ministry of Health, wrote to both the Bank of Ghana and the Controller and Accountant General, authorizing them to establish the letters of credit, which resulted in Big C General Trading Limited shipping the vehicles to Ghana. And Attorney General said, these two judges that formed the majority, it was they ignored it. What they ignored, they said, you were to forcing. Then some to me bien Free Ministry of Health say, on krata enko Bank of Ghana and the controller, enko establish a letter of credit, enko tuyeskebi, Emma Big C, and shepo sabakers in the family Ghana. Krata bien the one with their dance say, obi Free Ministry of Health, and a matter of forcing sa 2 minutes on church krata. There is no evidence to support that fact. Why did the majority on the Court of Appeal ignore that fact? That no evidence whatsoever support that Ato Forsen received any form of authorization from the ministry that was responsible for the purchasing of these ambulances. These are some of the particulars of errors. Yeah, the learned Attorney General is stated in his appeal to the Supreme Court. Interesting times ahead. Very, very interesting times ahead. Yenya bre ebubumu kakra dia mama said be yambati ase na mahu said the case ni seko. The other series of revelations in this appeal document. Stay tuned. Yankopon ya do mochina. Ye the part 3. Ebebro.